My objective is to first get you to know what the law is, discuss some cases, and then give you very specific examples that you can mix and match for various dates that you're willing to waive and other dates that you're not willing to waive. The handout, you should all have this outlined. If you don't, grab it. It might be useful, and you're going to need to take some notes because not all of my cases are in the handout. I've also been told that when I start talking, I talk very fast. So if I see you guys go like this, that means slow down. Okay. California does not like continuances in dependency court. A good example of this, you've got an incarcerated parent, you've got 60 days max to get to dispo. You can't get that incarcerated parent here during those 60 days. That's a secondary right. The kid's rights will go first. The one thing you need to walk out of here remembering, if you don't remember anything else in the next 59 minutes, if you do not state your objection, it is waived. Is that a slowdown? No. So basically, silence is consent to whatever continuance may exist. So the court, you're at detention, the court sets a jurisdiction date out 90 days, and you don't say a word because you're busy talking to your client or you just spaced that day. Guess what? You've just waived that. Okay. You've got your statutory law, which is the basics of both. Section 352, I'm not going to read it for you, but it's right there. That's your basic in California Rule of Court 5.550, subsection A. That gives you, hey, if there's good cause, we can give a continuance. Okay, it gets a little more complicated, but now, one of the things you want to do, you make an objection about a continuance. What you're going to do is make sure that the court's ruling is on the minute order. And say the court, you object, I don't want to waive XYZ date. The court says tough noogies and moves forward. You want to make sure that the basis for his or her going forward, the factual basis, is on the minute order, not just on the record, on the minute order, and that your objection is on the minute order. And if he grants your objection and decides to proceed that day, make sure that that too gets into the minute order. Dennis?
Can you give us the exact words that we should say when the court wants to set a date past the 60 days?
If you look at page 3 or 4 of your handout, you will have mix and match. Since I actually have an order for this, but if you turn to page 2, you're going to get the general. This is your generic objection to any continuance. Parent, mother, father, is objecting to the continuance proposed by the court, county council, the children's council, or another parent's council, as there's been no showing of good cause for the continuance as required by Section Welfare and Institutions Code Section 352 and California Rule of Court 5.550. The fact that the other party stipulated it's convenient for everyone. There's a pending criminal prosecution for your client or someone else. There's a pending family law matter, or the calendar is congested, is not good cause, and in and of itself is not the basis of a continuance. If the court goes ahead and continues, talk to your writ attorney. Okay. What I told you about putting things on the minute order, you want to do that because your writ attorney is going to ask you to prepare a declaration about what happened that day. And you're going to be able to get a minute order. Sorry, I should be turning this way. You need a minute order to attach to your writ petition. And if it's not in the minute order, it gets a little bit more complicated. So make sure, for history's sake, in the minute order. Okay, I'm going to bounce back to the basic cases. Okay, Jeff M., which is the first of your big handouts. Here, the petition was filed in July of 1996. It went forward to adjudication in June of 1997. Okay. Here were various reasons for continuances, some legit, some not. Got 3 new judges. So it was the third judge that ended up hearing the trial. Social worker was out ill. The attorneys all stipulated to continue. Then we started the opening statements. Judge got sick. Judge number 3 got sick, had to go to the hospital. He comes back before, against medical advice, starts the trial. Good parents attorney is still objecting. Hey, I want to move forward. I want to do this day to day. Sets it out a further time. Now, basically, basically, Jeff M. sets out the law for continuances in dependency court, okay? So it tells you what not to do. Oh, hey, I'm not feeling like it today. You're not feeling like it? Oh, kid's attorney, oh, they've got a doctor's appointment. Your Honor, we're all stipulating that we're going to continue this for 2 weeks. Okay. Renee S., that's your second case. I will note Jeff M. is in the 2nd district. Almost all of the cases that I'm citing today are 2nd district, which means that they are applicable here in Los Angeles. Other districts have other rules in certain cases. Okay. Renee S. is your next case. A no time waiver trial was set. They come back for the no time waiver. The attorney, the father's attorney, the court, father's attorney had a conflict. So the court puts it over, gets a new attorney. They come back. They try to find a day. This is up in Sacramento. Renee S. is not a 2nd district case. Long story short, Thursdays and Fridays are the only days that they can hear adjudicated or contested matters in Sacramento. So they kept putting this off. Finally, the parent's attorney, who had been objecting at each and every hearing, objecting to the continuances on all grounds, doing everything that parent's attorney was supposed to do, finally takes up a writ. Court of Appeals says, we don't care that Los Angeles, Sacramento, there are other cases in other counties, we don't care that your court calendar is congested. We don't care that you have 50 matters. This is to the judges. We don't care that you have 50 matters on today. To the attorneys, we don't care that you carry a caseload of 300 to 400 cases. Your trial, this trial, is going to go forward day to day for the entire day. It's up to the legislation to make new rules, giving us more money, more funding, more courtrooms. And so the court was very strict about it. Okay. I've explained to you at the beginning that time is of the essence. The prisoner's right to attend the disposition is a secondary right, secondary to the child's right for a speedy trial to get through this and get permanency of one sort or another. In Marlene M., another 2nd district case, Mom wanted more FR. She had done some stuff. She filed a motion. The court said, hey, it doesn't benefit the kid. You've had your reunification time. Boom, we're moving on, and that's it. Now, in the past couple of weeks, we've had 2 unpublished cases that I've put here. Oh, sorry, folks. Some smart aleck is going to ask me, okay, well, if you have to get through your case, maximum 6 months, what happens at the end of 6 months? You get to dismiss the petition if it hasn't gone to trial? The answer is no. There used to be case law and statute that allowed, as a sanction for not making your trials timely, dismiss the petition. Courts, of course, didn't like that. So when the legislature reworked the rules, it is now not specified as to exactly what happens when your trial date has run out past the 6 months. The petition doesn't get dismissed, it just keeps moving. The general answer will be asking your writ attorney early on in the process to file a writ on this. Okay. In Re JW is a 2nd district case. It talks, and it's attached in your packet here. Oh gosh. It was a case from October of 2016, a couple of months ago, basically saying that there are no sanctions for running past the deadline. Things don't, the mother tried to say, you removed my kid, we haven't gone to trial, it's been 6 months, return my kid, that's your sanction. Court said, no, it doesn't work that way. Unpublished, but the reasoning is very helpful. Okay. An issue, I don't think you have this case. Did I put in Emily? Sorry, folks, it was early this morning when I finally put this together. 2 cases before that, In re Emily D. The department rested its case, basically a drug case against mom. They didn't have any test results back from the lab. Department rest. Mother's attorney brings a 350C motion saying, hey, no positive test results because guess what? You don't have any lab results. Got to dismiss this petition against mom. The court, on its own motion, reopened the case, or didn't actually technically reopen the case. On the court's own motion, continued the case 3 days for the test results, essentially adding evidence into record, and the matter was written. The court can put witnesses on. The court can order evidence into the record. The court can question the witness that you have on. You can object, and the court gets to make a ruling on the objection. But the court can do all of this. This is a question that I've had my attorneys ask. It can happen. In this case, no harm, no foul. The fact that the court granted the continuance for 3 days was found not harmful because test results were positive, and ultimately that's what would have happened. The reasoning behind this was that this child's safety and protection was more important than a formality of continuances. So where everyone kind of knew that mom would be testing dirty, but the department didn't have actually the test results, it was perfectly appropriate for the court on its own motion to continue the matter for 3 days. Now what would properly be done is then reopen, allow the parent's attorney or mother's attorney to reopen the case and put on witnesses about that. But that's another story. Okay. Angelique C. is another one where the disposition was not done within 6 months. Things dragged out because essentially they were alleging that mother had a drug problem, that mother had mental illness. All of this, her prior case took place in New Mexico. It took months to get the records from New Mexico to prove that, basically to bypass her on reunification services. So at the end of 6 months, they still haven't gone to dispo. Mother is saying, hey, the sanction for going past 6 months, give me FR. Court of Appeal, their bottom line is, you've had 6 months while this is dragged out. You didn't do anything. You kept saying that this was merely a suggestion that you do XYZ programs. You slept on your rights. Goodbye. Okay. The courts are pretty harsh about this. Okay. Let me turn back to the memo. Sorry, folks. Okay. There we go. If you go to page 3, I am going to go through now the exact timelines that you need to know and your objections. Okay. You're in detention. You don't like what the department's putting on. You want to put on some witnesses, so you want to set essentially a 319, a contested 319. The court that has to be done within 3 court days. Around here, what happens with that is that they usually can't drag out a contested detention within 3 court days. So what the court does in response, and it is allowed to do so, is set a no-time waiver trial, which can jam you. So think very carefully before you set a contested detention, which is perfectly appropriate to do on occasion, but think carefully because you may end up with a no time waiver trial on the back end of that request. So, yes, Marlene?
But isn't that within 10 days, so they even narrow it? They can do it within 10 days, not even 15. You have even less.
That's correct. Let me read you the California Rule of Court, or you'll see it here. If the child is detained and the parent sets a contested detention hearing, that hearing must be set within 3 court days, or we go straight to the jurisdictional hearing within 10 court days, which is usually 2 weeks, because 14 days, 2 weeks because of the weekends. Okay. Now, the court wants to go to the no time waiver. You want to go forward today, tomorrow, because you've got the kid's school teacher or you've got some other great witness who's available tomorrow and you want to get that kid home with the parent now, not wait till jurisdiction or disposition, which may drag out. Your objection is right there. Mother, father is not waiving his, her right to have the prima facie hearing set within the statutory time limits of California Rule of Court 5.680 lowercase d. Okay, you don't set a contested hearing. If the child is detained, that's supposed to go to trial in 15 days. How many of you have had that happen? Okay, in 9 years in trial court, I never had that happen. Now, what happens, most of us, when the court is setting out a jurisdiction hearing 3-4 weeks from now, in some courtrooms, we won't mention which courtrooms, but in some courtrooms, let's say it's more like 6 weeks, 8 weeks, 10 weeks from now. If you don't object, hey, the kid's out of my client's care, I want that trial within 10 days, within your statutory right, sorry, I didn't have my glasses, within those 15 days. If you don't make that objection, you have waived the right to go forward with trial, and that can drag out forever. You can continue making other objections when you come back for the later hearings, but you have just waived that issue. Okay, now, if the child's home with a parent, you've got 30 days to go to trial, okay? Let's say the court wants to set it for 40 days. What do? Object. The third objection down on the page. Just read it, substitute in mother, father, his, her rights, and put it in there. That is a formal objection that will hold up on an appellate level. Okay, now, let's say 10 detentions, one ends up getting trailed till tomorrow. Tomorrow, you come, the next day, let's say it's Thursday, you come in, there is 5 trials, how many units of XYZ, one of which is an E-trial. Guess what? That detention takes priority, but you have to assert that objection at calendar call. And it goes something to the effect that we're not waiving the mandate under Section Welfare and Institutions Code Section 345 that this matter be granted precedence on today's calendar. That way you get your detention heard right away and everyone can go home. Again, I will point out that this is, in theory, what can happen. I understand that in practice it can be very different when you actually get into the courtrooms. But in theory, that detention is to take priority, even on the day that is the day it comes in. Okay. You've gone past the detention. Now we're going to do some mixing and matching, but we're going to start now with your jurisdiction hearings. Okay. You've gone through jurisdiction. You've either settled the case or you've done a hotly contested trial or not so hotly contested trial, and you're now talking about the disposition of the case. How are we going to fix this? Okay. Now, if the kid is in foster care or with a relative out of the parent's care, but reunification is being offered, 10 days. You're supposed to put that disposition out 10 days, no more. Again, here's your objection. We are objecting to the court setting this out 4 weeks because I need to have it done by law within 10 days. Get that objection on the record and in the minute order, all of these. Okay. Now, If the kid's home with one of the parents, you've got the 30 days from the date of the jurisdiction. You have 30 days for the jurisdiction where the kid's home. You have another 30 days. That's your magic 60 days. Okay. Now, here is your mix and match. Let's say, okay, the child's home with a parent. The court sets it out 30 days. You come back on 30 days. There is an additional 15-day that can be applied by the courts, bringing it out to 45 days, okay? Now, here's what you can do. You can object. You can say, I am okay going past the 30 days, but I'm not okay going out 45 days. In other words, you can accept, very specifically waive your objection and accept the 30 days, but retain your right and object to the 45 days. Do that ahead of time, because often in the fray of things in the courtroom, you will forget to do it. And what happens? You have waived your objection. Yes? Sure.
Okay, so I've had the situation where I set it as a waiver, that's like 5, he sustains, and then says, well, I'm setting dispo out. I can set dispo out.
Is the kid home with one parent?
He says, I don't have to I can't have the dispo. No, for my objection, dispo out.
That would have been, the judge was not correct. Which objection that would go to? Okay, the very on page 4, at the top of the page, after the jurisdiction hearing, the court may continue the disposition hearing. Reunification is being offered, but the child's detained 10 days. Okay. Child's not detained, then you have the 30 days. That's the example I was giving you. You don't get to add the first 30 days if you did, like the 30 days that you had to do the jurisdiction. The court doesn't get to tack on those 25 days or 20 days onto the disposition hearing. I've never heard of that, and believe me, I've read a lot of case law in this area, and there is no case law that allows that. That was just going in a prayer. Any other questions before I go on?
I have a question.
Yes.
I'm very confused though by this. Is the time set based on where the child is, or does each independent parent, is it whether the child is...
Where the child is. Everything's about the child.
Okay, so if the child is released from one parent and detained from the other parent, it's 30 days.
That's correct.
The parent can't say, no, the child's detained from me, so I get the 16 days.
Bingo. No other questions. Okay. So, next page. Here's a bypass. Kids detained. They're not planning to do reunification services. Okay. Because you want to have as much time as possible to get your client into a program, to get him into a shelter, to do whatever you need to try to get the FR, or the reunification services. In this case, you're going to be okay with the court extending it out the maximum 30 days, because that buys you time to get your client convinced, hey, go into a drug program, get into your DB classes, do X, Y, Z, and it gives them time to show that they've actually shown up, a couple of clean tests, or maybe a dirty test and then a clean test. It does show that the parent is immediately putting it in gear and trying to avail themselves, I think is the magic term, of the services offered, even if they're not technically offered. At detention, you know those magic words that the court says that we're going to offer services to the parents, blah, blah, blah. That is reunification services on a temporary basis until you get to the disposition. Your client should grab that offer and move on, again, in a perfect world. Okay. Now, I went through at the very beginning. I'm going to hit it again because it's important. Under no circumstances are you supposed to go out beyond 6 months for a trial and adjudication, for an adjudication and disposition. It happens all the time. There are unpublished cases where things have dragged out 2.5 years. There was case law saying that the punishment for dragging out, it was in the second district, the punishment for dragging out a case for 2.5 years and still not having finished trial, petition dismissed. It was a sex abuse case. In re Justin C. Again, that result was not, the Court of Appeal did not agree with that. And Justin C. was depublished, I think. That's not the official term, but it was ordered not published by the Court of Appeal, basically saying that there is no sanction or specified sanction for running out past your 6 months. Okay, all of this is in your handouts. You've got your little, some of your cases. Again, I gave you a couple of unpublished cases. I like them because if the second district has not issued an opinion, a published opinion on a particular issue, if you're going to writ that or appeal that, you want to know where they're headed and use whatever magic language. Sometimes you hit an issue that you don't know anything about. You find this great unpublished case. Guess what? Everything has just been laid out for you, and you can take that argument. You can't cite the case, but you can take the argument, apply your facts, and you know that it's going to be heard by the Court of Appeal, and probably well heard if that's what generally the unpublished cases go in that direction. Okay. Now, question.
You said under no circumstances should the case go beyond 6 months for
disposition.
What if the kid is AWOL?
Then you can't get to disposition. You have to have the child to go forward to disposition.
In that case, you can't keep.
Yeah, in that case, you can continue beyond that. Yes, in that particular case, you can continue beyond that. Although I'm sure a parent's attorney, a good parent's attorney, could argue, maybe take a writ saying, "Hey, you don't have a kid. We don't see the problem."
Right.
It may have been tried. I don't know. I haven't researched that issue. Hold on 1 second. Behind you.
What about ICWA notice issues? I've had cases where DCFS doesn't send out timely ICWA notices. They need to wait to see if they get a response. The court says, well, we can't report on disposition until after we receive no response after 60 days.
Well, as a parent's attorney, what I would do is argue that the department isn't doing its job in timely getting out those notices and following up with the procedure in the Bureau of Indian Affairs, trying to get a response to those notices, or the department is dragging its feet interviewing relatives to get the information to send off those notices. The court can't go forward with disposition as to a Native American child without having the notices properly done.
Okay,
so
make the objections that there's no real remedy.
Yes, well, there is a remedy, and that is if you keep coming back every 2 weeks and nothing has happened, at some point you talk to your writ attorney and you get it up in front of the Court of Appeal saying, hey, this is absurd, sit on the department. Hang on 1 second.
The question I had, so we're making these objections, obviously our current due process lines, rights are being blown past, whatever, statutory guidelines are not being kept. Everything you told me is that when they examine this, there's really no relief. There's no kind of blowback from them doing this. All I've heard is we make the objection, they're like, okay, that really sucks, too bad for your client, but there's no relief. They're not going to dismiss a petition, even in egregious cases, where 2.5 years down the line they still haven't adjudicated. And I'm just wondering, so we're making objections, but unless we hit the DCFS or the court to the pocketbook or something, nothing's really going to happen. So what are we trying to accomplish here?
What you're trying to do is get a good record here at a trial level, and that's what your writ attorneys are for. Sorry for the other writ attorneys who may end up with more work on this. What you want to do is after it happens the second time and you're getting frustrated, what you do is you talk to your writ attorney, because you need to know exactly what information your writ attorney needs to do a writ. You go into the hearing and you do everything you need to get the basis for a writ. Your writ attorney can then turn around and get a writ of mandate, a writ of prohibition, and take it up to the Court of Appeal. The judges, the court officers, the bench officers do not like getting reversed. And while appeals and writs are not they're not a quick answer necessarily. They're the only remedy we have. Okay, and they can be done, and there are some firms that are very active. Speaking of which, Marlene?
I think that the real issue here, and I understand your frustration, but ultimately, the court is going to have to deal with this problem. And we cannot be waiving time on clients. So what will eventually happen when enough writs are successful is they're going to have to put out the money. That's how they get hit. Because, eventually, the appellate court is directing the trial courts to do something. If they don't do something, do our clients then have private, can they go to private counsel? Can they sue? I don't know. They can get creative also. But we are the ones that have to raise the issue. It's up to the courts to then decide if they're going to put out the money to open up more courts or do whatever they need to do to stop violating our clients' rights to these issues. In other counties, it's not as critical as in Los Angeles County. They actually do it within the timelines. We are totally out of control here. So somewhere along the line, we have to tighten up. And the court will have to respond, but we first need to have these successful writs and these successful remedies coming down from the appellate courts. And that's why we're really, it's either two people are going to pay for this. Either the judges are going to pay or we're going to pay for ineffective assistance of counsel. So I would rather the court has to deal with this. So that's why we're training, and that's why you guys really need to understand this.
Yes, I will summarize for those of you who may not have heard. The idea behind this training, I don't know what kind of job I'm doing at it, but the idea is to get you focused on this issue of continuance. Obviously, the appellate courts are looking at it. We've had 2 unpublished decisions within a week. One of them was on February 2nd on this issue. Okay? What Marlene is saying is that if enough of us writ things and the Court of Appeal has to deal with 25 writs on the same issue, something's going to budge. But until that happens, we're just going to go through this thing of allowing the continuances. Part of this training is to make you aware what the timelines are and to actually sit down and when you're at trial or when you're at these hearings is actually make the objections. Some of them you may feel less than inspired to make on behalf of your client, but what we're trying to do is essentially get this court system to fund more courtrooms so that we can have workable caseloads, that we can really focus and defend these clients the way we would like to defend them in theory, but in practice ends up falling short simply because of the overwhelming caseloads, both within the courts and on our own desks. So one of the ways we're trying to do this, I think this was Ken's idea, was let's get the writs going, let's get the objections going, and see what happens and see if that can budge this. Okay. Yes.
Back to the ICWA issue, how come on the upper corner of the case plan it says HOP, SP, and then ICWA pending? Can you go forward?
Because some judges do go forward, and I'm going to be really honest. This is not an issue I know a lot about, and rather than give you a wrong answer, I am going to defer to Jessica Jorgensen, who is doing an ICWA training after lunch. And I think maybe you can, if you want an answer today, she would be the right person to ask because I'm giving you my general knowledge. I've not researched the issue, and I don't want you guys going out there and saying, but this person said. If you want me to, I can research the issue afterwards and get back with you. I have no problems doing that. But if you want an answer today, Jessica Jorgensen is going to be your best bet. Yes.
What is the remedy when Hague issues is the problem? The 6 months that it takes them to notice Hague. So what would be the remedy for the other parent who?
You're going to be the parent jumping up and down in court, insisting that you come back every week and writing the department. Has the department done the same thing with the ICPC, same thing with servicemen, same thing with prisoners? All of it is what you want to do is get that case in front of the judge as often as possible to push the department faster to do it. It's not going to fix it because there is no sanction for going beyond that 6 months. This is one of those areas of law where you're being told by the legislature, this is what's going to be done, but what ends up happening through the court system is that it's not getting done, and there is an inherent conflict there. And maybe that's an issue we need to look at, but part of the reason there is no sanctions is the idea that a child who has been horribly harmed merely because the parent's attorney dragged their feet, kid's attorney, county council, whoever dragged their feet, dragged it out long enough, got dismissed, okay? Say you're here on one of these family law custody battles that ends up actually harming the kid, and you keep putting that off, and finding some reason to continue trial. Boom, 6 months is up. Oh, okay, we can dismiss the petition. We can go back to family law court. It doesn't work that way. The system is geared toward protecting kids, and any rules that trespass on protecting kids is going to end up being kind of fuzzy-ended.
Well, that's not really accurate, because if there's a dismissal because of a procedural reason, then it's not dismissed on the merits.
What's that?
Turn around and file again. The is that the timeline now starts over again.
Yes.
And the reunification times. So really, that's a perfect resolution, to dismiss the case without prejudice, let the department file again in 2 or 3 days, we get the timelines going again. To do it the other way means essentially the parents are being, the game clock is running out on the parents who don't get the reunification per the statutory structure.
Res judicata?
Pardon me?
Res judicata?
No, because it's done without prejudice. There's no
Fair
res
enough.
judicata. You can only have that if it's done on the merits.
That is as good a trial, a great argument. A good trial attorney, a great argument. This is what I would argue back. You mean this child who was molested by her stepfather, we're going to drag this out for 2.5 years. She's going to age out of the system. In the meantime, that child has not gotten any emotional counseling. She hasn't had any ex-counseling for child abuse. She hasn't received therapy for this. It harms the child when you drag stuff out.
Then don't, as a court then, Your Honor, don't allow it to get dragged out. That's your responsibility.
Perfect.
And by the by, the department has supposedly been giving these services during the time that this thing's been pending. Now, we've dragged this out for a year without a trial date, and you've just ran the clock out on my parents. That's not right. That's a violation of due process.
And that is the argument you will be making. Okay. I agree. Yes.
With respect to the whole exceptions to the no excessive continuances thing, what about when there's due diligence pending on a whereabouts unknown parents?
Again, this is like the ICWA issue or your incarcerated parent trying to get them there. You want to have that case brought in on a date. You can push for a daily basis, maybe every week, like every Friday, you want that case on, Your Honor, so we can check the department's status. I want the social worker here to find out what work has been done the past couple of weeks. In other words, again, what you're trying to do is push the process the way it's at the speed that it's meant to go as opposed to the speed that it's actually going to go.
But they won't go forward with this though without having that done. They don't want to set themselves up for things.
No, and that's why we object and hopefully getting some writs out there. Okay.
I mean, just to kind of clarify your point, I had a similar question. You're just trying to say that your good cause to go forward is better than their good cause to continue, right? Okay.
What you're balancing is good cause versus the child, what's going to help benefit the child. And it's right there in 352 in the language, and those are the two things you're balancing. As a parent's attorney, sometimes you want those continuances, sometimes you really don't. You will have arguments now both ways to get them.
I don't want to beat a dead horse with this, but specifically with the Hague and ICWA notices, where you have this sort of set timeline of, okay, you send out the notices and then you wait for either a response or no response within 60 days. I wouldn't expect my judge or any other judge really to want to come back on a weekly basis to check on that, because what's usually happened is you come back on the trial date and you say, oh, you've been sending the notices, I sent them a week ago. And if you sent them a week ago, the judge just thinks, well, we need to wait 60 days from that date, or 60 days from that date. They're not going to come back every week to say this department did their job this week. They did last week, they did late.
As a parent's attorney, I would want to argue that that is exactly what we want. And if it congests the calendar, well, then the court needs to start sanctioning the department for not moving and doing what it's supposed to do.
I expect to actually see on the basis that they sent paper notices last week, and all we're doing is waiting 6 days.
What you're trying to do is prevent them from sending it last week, but having it sent right after the detention, okay? Rather than that kind of period of time where everything kind of lags, and then like a few days before trial or 10 days before trial, all of a sudden the social worker kicks it in gear. Oh my God, we're going to have a court hearing on this. Let's send out notices. Let's do this. Let's do that. And what you're trying to do is prevent that. Your Honor, if notices are going to be an issue in this case, rather than waiting until trial and having it continued, because not, we have status progress, a non-appearance progress report on the issue and when notices were sent out, so we can have a good idea about the response. They're not going to like it, but we're parents' attorneys. They're not necessarily going to like a lot of things we do.
So in your groups where a parent raises a court issue, it has to pass for a week or something like that to
Sure.
after to see if it goes or something?
Yes, because the department usually has to interview relatives to find out whose grandmother belonged to which tribe. And what happens, the social worker gets this, it sits on her desk. Sometime they start seeing that, oh, I have to prepare the jurisdiction disposition report. I better interview those relatives. If you come back a week or 2 weeks after detention, the department, what do you mean you haven't interviewed these relatives? Here's the phone number. We gave it to you at detention. Why haven't you interviewed them to get the information to do the notices? In other words, you start pushing from the very get-go to get the process done on a timely basis. Again, this is in theory. I understand that in practice it may not be a very practical solution, but in theory what we're trying to do is push the department so that there aren't these delays when we get there at the hearing and, oh, well, the report just got here and, the witness isn't going to be available. In other words, the department pushes everything until last minute and the whole process gets bumped. Same could be said for us, but for all attorneys, but we want to do our part to move it along. Yes, Marlene?
If we have the kind of case where our client just got into the drug program, it would be beneficial for the client to have, let's say, 30 to 40 to 45 days. Then
we want that continuance, and we're not going to object. We're going to waive. We're going to remain silent.
What I'm trying to say is can we say to the court that we would waive time to 30 days or 15 days, but we won't waive time to go beyond the statutory 60 days?
Absolutely.
Now, if it is an input issue, we could ask the court to set a pretrial conference, JDX, PRC, whatever the flavor of the day is, and that the department has to show by that PRC date what the status of the notices are and to have the returns by that date. And if not, the social worker has to be in court and, sanctions or whatever, but to keep the pressure on. So if we're going to go out to the 60 days, to be able to at least at a 30-day mark do a PRC with the social worker present or something specifically on the IPWA or
Your Honor, I'm willing to waive XYZ deadline. However, that waiver is conditional on the fact we come back on a non-progress hearing next week to address the progress of the social worker on XYZ issue. And you don't have to just flat out waive or flat out object. There's all this gray area in between. Conditional waivers. And the court really wants to set this thing out really long time. You can use that, okay. I will allow that if you give me this. I want a non-progress every 2 weeks. Okay. I did not bring my phone, so I don't know the exact time. I want to run through a couple of just minor little points, and I'll take more questions. I have 15 minutes. Oh, so I've got plenty of time. Oh, you guys are in for a treat. Okay. Did you know that there is a JV form for continuances in dependency? You can print up the form, check off the box, and fill it out. You don't have to, oh my God, how do I make a motion for a continuance? What am I supposed to, what's the law on this? It is form, get ready to write this, or you can email me afterwards, JV 406, continuance form for general dependency, okay? Now, a question I was asked by Ken as we were discussing some of this on an earlier date. Well, these continuance motion, how are they supposed to be done? Well, technically, they're supposed to be written. You're supposed to give 2 court days notice of a continuance request in writing with declarations supporting that request. Now, again, people who have been here, 20 years, have any of you ever seen such a thing? Dennis?
Well, I just want to say it's not just technically one of the biggest victories of my life that I got in Marquette's courtroom, and I stopped an adoption and got a voluntary relinquishment to my client's family, and then it got completely overturned because I had made a request for continuance that was not timely. The whole thing got overturned on that basis. So, yes, there is precedent for it being a real victory.
Okay. Now, the written notice must be filed 2 days prior to the hearing with declarations, unless there's good cause to allow verbal notice. So guess what happens here? Verbal notice. I have never once, and I'm sure people who have been practicing a great deal longer than I have in dependency have never seen a written continuance request. Okay. So that's your answer. Okay, now, let's say you've got some, I learned a new word today, service member, all together as one word, not servicemen or servicewomen, service members. There is the Service Member Civil Relief Act. Basically, it gives a 90-day continuance, a 90-day stay to anyone who is in active military duty. So you get appointed for some client who's overseas doing God knows what in God knows what country. You have 90 days, and that is going to trump these statutory deadlines. There's always a certain amount of play again, but if you get appointed for that service person, use that continuance. Try to get information from the family, try to contact your client, and use that time. Okay, if you need the site, I will give it to you, just email me. Now, part of that had originally been enacted because there was a lot of family law disputes that when husband or wife was overseas, the other parent would then file for custody in court and take a default. So that was part of the reason that was enacted. Okay. I told you about the incarcerated parent's statutory right to attend the disposition hearing is not good cause for continuance beyond the 60 days. Okay. Now, let me make sure that I've got, okay, due process. Someone brought up that issue. Most of the cases that are decided are brought up as continuances end up being, the flip side of that is due process. What right does a parent have? If you look at the most recent unpublished case that came down, it is, okay, oh gosh. I'm sorry, folks, I have misplaced a case. It will be in this packet and it'll come to me. Let me just go ahead and move on. I've had questions about variance. In other words, one of the issues with continuances, the day of your trial, the department wants to file a new amended petition, okay, with new facts. Or you go to trial and the court says, well, I'm going to dismiss A, B, and D, but guess what? I'm going to sustain a C count. You have notice issues there. Your Honor, wait a second. My client, mother, father, had no notice that these allegations were made against them. It was in a sex abuse case. Basically what happened is, historically in the family, I think it was stepfather had abused the oldest daughter. By the time that all of this came out, several years had passed, although she was still, I think, a teenager. They go to trial, and the court finds that there's no current risk of sex abuse because all of this happened in the past, and dismisses the D count, but doesn't want the child to go without therapy, and essentially sustains a C count, saying, oh, she was emotionally harmed. The parents should have known and should have got her treatment after she was abused. Okay. This is where you would be standing up and shouting, Frank, for a continuance. The judge cannot, or the court, cannot amend a petition if you haven't had factual notice of what is coming. In other words, here's the case now. In Re MW, it was the case that came down on January 31st of this year. 355.1D shifts the burden. You've got a registered sex offender as a client. In the detention report, it mentions that he's a sex offender, and a registered sex offender needs to register the whole shebang. Now, what this defense attorney didn't know, when we get to trial, 355.1 subsection D shifts the burden. Once you have a registered sex offender, it's automatically...
It's what burden?
Huh?
It shifts what burden?
Burden of proof. The department has to prove that there's a risk to a child on the 300 petition. Huh?
Isn't it the burden of producing evidence?
Yes. I think that's just the other side of the same coin, but yes. Basically, the department has to show that this child is at risk of harm. You have a registered sex offender. It is obvious that there is some risk to the child. The burden of proof, the department has just now met its burden of proof by showing that this is a registered sex offender, and it is now up to you as a parent's attorney to shift the burden back. There is no risk to the child. Burden of proof, and yes, that would be evidence. Sorry. Here's the little kink in the case. In the detention report, there was mention that the guy was a registered sex offender. There was not a allegation in a 300 petition having anything to do with the sex offender. This trial attorney, he comes in, he's ready to go to trial, and he goes, well, the department didn't mention anything about a shift of burden. There was nothing in the papers. This is due process violation. I want a continuance because I had no notice that the burden had shifted. And the courts basically said, tough noogies. When you receive that detention report, and it said that they had attached the little registered sex offender, here's this criminal thing, needs to register. It's usually on the CLETS. That was your notice that you're a registered sex offender, and they use the magic language in 355.1. I highlighted this magic language. Hang on. Okay. Such injuries would not ordinarily occur except as the result of deliberate, unreasonable, and neglectful acts by the mother who had care, custody, and control of the child. You get that language? Guess what? You've just been put on notice that the burden shifted. That language, hidden in the petitions, So you come to trial and you're ready, well, the department needs to do this case. Guess what? The department's already done the case, and it's up to you now to show that there is no risk. That you, in this particular case, the trial court, the appellate court said to the father's attorney, you had 2 months and a week knowing that he was a registered sex offender. There's the magic language. There is no need for the department to wave a red flag saying, here is your factual issues. You as a parent's attorney need to go through that file, and you need to look at every possible thing that can be alleged from the facts that are set forth in the detention report and in the petition, okay? The court wants to amend the petition to proof, and you start jumping up and down saying, I want a continuance. You've slept on your rights and your client's not going to be happy. You need to go through that and figure out anything the department could argue, or minors counsel can argue, or that the court could find to be an allegation, even if it's not pled in the actual petition. But the facts have to be there. In other words, if the problem in this case was there were no facts showing that this girl suffered any emotional harm, so they couldn't plead it under a C. Sorry, I'm bringing it back here. Did everyone understand that?
What is the basis for the amended conform to proof language by the judge is not in the reports, but based on information in a family law file?
Have you received the family law file and looked at it? In other words,
no.
Is it in evidence here?
Well, the court has the file, but it has not. You have not received anything.
If the court has the file and has access to that information, counsel should have access to that information, and it is your obligation, sorry to say, to read through that family law file. I would argue that it's kind of like discovery, where you bury them back in civil litigation. You have the burning gun document, the 1 page, and you bury it in 1 million pages that you turn over to the other side. Let them find that one burning, the burning. It's a similar thing. The department could, theoretically, you have the family law file. I haven't seen where that has actually happened. But yes, if the facts have been put into evidence, and on those facts they can actually state a cause of action or an allegation, a 300 under a 300 A, B, C, D, whatever, then they can amend to proof. Now, here's the little twist. If the court wants to do something and there's not adequate notice, what the court can do is say, and this is in some cases, hey, counsel, this is what I'm thinking of doing. You, parent's attorney, I'm going to give you a chance to reopen your case in 10 days and put on any witnesses or any evidence refuting this particular issue. Here's my proposed amended language. That's the way they're supposed to do it if they want to conform to proof, and there's not enough of a factual basis. They need to give you that notice, or the parents that notice, and then give you a time to actually defend against it. To just do it willy-nilly doesn't work, and again, that's either a writ attorney or an appeals job.
And in the case that I was with similar facts, you could go beyond 10 days if you need to get a copy of the file.
I would think, I've had this situation happen. I would think that yes, you would need to go beyond that time to get the family, but then once you open that door, you need to be very careful, and that's where I would do a conditional waiver. Your Honor, I will waive the 10 days. Oh, I'm sorry, this wasn't a deadline issue. The court was only giving you 10 days. You tell the court, hey, that this is, 5,000 pages worth of bitter dispute that lasted over 5 years and X number of transcripts. Your Honor, I'm going to need more than, 5 working days, 10 working days to do this.
If the court's inclined to conform to proof basically by adding a new count, are you entitled to ask for,
Yes, you're entitled to ask for a continuance.
Well, right, and you get that continuance.
You should if the facts weren't there.
Actual language of what it's supposed to be. We had this come up the other day. We got a continuance, and I was like, okay, what's your language look like, minors counsel? Oh, I don't know. It's going to say something like this. What? So are you entitled to you're entitled to notice from what the petition looks like, when the department wants to add a council file and amend it. So I understand that, so I was trying to use that
For minors
for
council.
minors council.
Basically, once they pointed out facts, for example, let's say that no one knew that the guy was a registered sex offender, and minors council tells you, hey, I want to amend this petition. The department doesn't know this yet, but the guy's a registered sex offender. I want to amend the petition. You get time to actually go and do some time to defend against that.
You're not entitled to what a council read or actual notice of something.
You're entitled to notice of the facts upon which a legal allegation can be based. So I don't care if it's a word here, word there, or like in this one case, you guys have this. It's MW. As legal counsel for parents, we are entrusted to know the law and to be able to look at detention reports, attachments, petitions, little hints from children's counsel or other counsel about something else. That should put you on notice that there's a factual basis for, and then you have to go and look, are all the elements for a cause of action for, sorry, I'm using tort language, but are all the elements for an A count there? And go back through your file and check it. They've put you on notice. Now, you are entitled to discovery, and you can do informal or formal discovery saying, hey, you said you want to amend X, Y, Z. What's your evidence? What are you relying on? And do it formally as a discovery motion. That would be an alternative, although it would keep you up until midnight doing it right away. But I'm sure there's a form around. Tell me that there's no questions.
Thank you.
I know.
That was awesome.
Okay. The last thing I will say, this variance issue is one that I just kind of touched the tip of the iceberg here. Deserves a whole another seminar. So if you have any suggestions about that, let me know. Thank you.
Thanks.
I probably never remember once, did I? I will. Yeah. Did it come through, John? Thank you so much.